So the Supreme Court has issued an order in a critical Second Amendment Preservation Act challenge that was pending in front of them. So let's talk about what happened in this critical case and where it goes from here. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. You can also click the notification bell and turn on all notifications because that helps to ensure that YouTube will send you these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always expanding upon their benefits and trying to give you the most, benefits and coverage for your membership. So again, if you're interested, check them out using the link down below. And if you use my code ARMSCHOLAR, you can get $25 off of your sign-up fee. As I mentioned in the intro, in this video, we will be discussing a very significant Second Amendment Preservation Act case and protection case that was seeking Supreme Court emergency review. This is a case dealing with a state's Second Amendment Preservation Act, also known as a SAPA law. And we've discussed this case in the past because in the past, essentially, the Supreme Court issued an 8-1 order denying a stay which would have protected Missouri's SAPA law. This case went back in front of the Supreme Court, and recently we got an answer from the court. The Supreme Court, in a recent order list, denied emergency review to the Missouri SAPA case. But this case is not yet done, and there's a lot still that can develop in this case. Now, you might remember that in this case, the Trump administration continued to argue that the SAPA law is invalid in some of its applications, and that the Supreme Court should deny review. However, at the same time, they stated that if the court denies review, the government would release some of the judgment that they received from the lower court. The administration told the Supreme Court that this case would eventually get back in the hands of the lower court, and when it did, they would release that total injunction that was granted prior to the Biden administration. Now, the state of Missouri responded to those arguments by pointing out that that concession made by the Trump DOJ is exactly why the Supreme Court should in fact grant review to this case after they held conference. And Missouri also raised concerns that maybe the Trump DOJ would not stay true to their word once this case got back in the hands of the lower court. But unfortunately, the Supreme Court took the administration's word and decided to deny review to this case. That then left the door open for the administration to remove some of the prior ruling and the complete injunction that was issued to the Biden administration at that time, and essentially they have the opening now to remove that total injunction like they said they would. However, to this point, even months after the Supreme Court denied review to this case, the Trump DOJ still has not yet moved for the lower court to remove the complete injunction that was issued. Now, this lawsuit revolves around the 2021 Second Amendment Preservation Act that was passed in the state of Missouri. That law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies in their attempts to enforce federal laws that violate the Second Amendment. The law prohibits Missouri's officers, agents, and government officials from helping federal agents who are attempting to enforce those laws. The law also created a civil remedy where any resident of the state of Missouri could sue a Missouri official if that official helped to enforce federal laws that are believed to violate the Second Amendment. So the law really aimed to give the true enforcement powers to the residents instead of any of the state officers or agents. Now, in this Missouri case, the District Court on Review ruled in favor of the then Biden administration, who brought a lawsuit against this law in Missouri, and ultimately the court decided to strike down the Missouri Preservation Act in its entirety. In response, the state of Missouri then appealed up to the 8th Circuit, and Missouri at that time also wanted a temporary stay on the lower court's total injunction, and they wanted a temporary halt on that at least while the case was moving forward. But at that time, the 8th Circuit decided to not grant them that stay, and that led them to seek emergency Supreme Court intervention. However, when the Supreme Court reviewed the emergency request for a stay, the Supreme Court issued an 8-1 order denying that stay request. Only Justice Thomas was in favor of granting that stay and allowing some of the SAPA law to go into effect. Now, after the Supreme Court denied review to this case the first time, it was sent back to the 8th Circuit for further arguments and a decision, and the 8th Circuit ultimately ruled and reviewed this case, and they ruled in favor of the federal government striking down the SAPA law once again entirely. But then Missouri once again went to the Supreme Court and were seeking review. Now, one of the big things that Missouri pointed out when they were seeking Supreme Court review was the fact that the 8th Circuit essentially said that the structure and potential operation of this law is valid, but they ultimately struck it down because they did not like the underlying Second Amendment purpose. Missouri argued that the 8th Circuit went against clear precedent and found that state officials could be sued because the court believed that the state played a role in enforcement by simply complying with the state law. Essentially, the 8th Circuit found that compliance and non-action was still enforcement and action. Now, this law was originally opposed by the Biden administration, like I mentioned, but then the Trump administration got control of this case. And initially at the Supreme Court level, they stalled this out for multiple months. And then we finally got the answer from the Trump administration. And they continued to argue that the SAPA law is invalid, at least in most of its applications, and that the lower court got the decision correct. However, really at the same time, they also argued that if the Supreme Court denied this emergency review request, if they kicked this case and it got back in the hands of the district court, the Trump administration, the federal government, would ultimately decide to dismiss some of that total injunction that was won by the Biden administration. The Trump DOJ stated to the Supreme Court that having reevaluated this case, the United States has concerns about whether the judgment below extends too far and enjoins applications of the act that do constitute mere non-enforcement of federal law protected under the anti-commandeering doctrine. And those concerns are exacerbated by the uncertainty in this pre-enforcement posture about how certain provisions of the act will be applied and about whether the provisions on which the 8th Circuit focused are indeed inseparable from the rest of the act. They stated that given those concerns, the United States has decided that it would acquiesce in narrowing the scope of the judgment when the district court regains jurisdiction over this case. So after stalling the case for a few months, the Trump DOJ then responded by continuing to argue that the SAPA law is invalid, that the Supreme Court should ultimately deny review to this case, but at the same time they said that if the Supreme Court denied review to this case and it got kicked back down to the lower court, they would release some of that total injunction that was won by the prior administration. And unfortunately, the Supreme Court sided with the administration in this case. In a recent order, which was issued by the Supreme Court, they denied review to this SAPA law. They did not take the emergency review that was requested by the state of Missouri, and therefore it's going to head back down to the lower court. Now, despite that denial, this case is not yet done and it will still move forward. As the United States stated in that request for the denial, once this gets back in the hands of the district court, they stated that they would release that total preliminary injunction that was issued against the Missouri SAPA law. So there may be some ways in which the SAPA law will be implemented at some point, at least some aspects of it, as it moves forward towards a final merits judgment. However, there is a larger concern that I have and others have, and that is the fact that to this point, the Trump DOJ and really, there has been no lower court effort to remove the total injunction that was issued in this case and no fulfilling of the promise that was made to the Supreme Court. Recently, a notice from the Supreme Court went out to the 8th Circuit and to the Missouri District Court that are handling this case, essentially saying that the case was denied review by the Supreme Court and therefore it is closed out at the Supreme Court level. So now the denial is official, and you would assume that there will be efforts at some point to release the total injunction that was issued by the lower court. But like I mentioned, to this point, we have not seen the Trump administration move to fulfill that promise. So that's what's currently going on in this critical case. As we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm or Al Gore's rhythm. It adds fuel to his jet and just tells the YouTube algorithm that you appreciate this type of 2A content and it should share it to more people. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.